Across courtrooms, grant offices, and agency desks, there is a quiet, often overlooked mechanism that ties individuals and organizations into the web of public law, the acceptance of government grants. Today we examine how agency relationships, contractual terms, and legal presumptions can attach a recipient to statutory regimes and administrative oversight simply by agreeing to receive funds. This is not a political story about policy choices. It is a procedural and doctrinal inquiry into how legal relationships are formed and how those relationships create records, obligations, and presumptions that matter for jurisdictional questions. The fulcrum for this episode is a recent Federal Register notice, OMB, Regulation for Federal Financial Assistance, identified as FR Doc 226-1817, published May 29, 2026. That notice proposes revisions to the Office of Management and Budget's guidance on federal financial assistance, the modern administrative text that frames how federal grants, cooperative agreements, and other forms of assistance are structured and administered. To understand the regulatory baseline, the uniform administrative requirements, cost principles, and audit requirements for federal awards, codified at 2 CFR Part 200, and frequently called the Uniform Guidance, remains central. Those codified rules set out definitions for recipients, subrecipients, pass-through entities, cost allowability, audit thresholds, and the flow-down of federal terms and conditions. On the procedural side, the Administrative Procedure Act, 5 U.S.C. Prof. 551 et seq., provides the vehicle by which agencies publish rules, solicit comment, and finalize regulations, procedures reflected in the May 29 notice. For statutory grant authority, look to the United States Code provisions authorizing financial assistance, including parts of Title 31, the chapters that address grants and agreements, which supply the congressional hook for agency action and conditions attached to funds. Historically and doctrinally, questions of how and when governance and adjudicatory power reach a person connect back to foundational jurisdictional cases. Pennoyer v. Neff, 95 U.S. 714, 1878, the 19th century articulation of territorial sovereignty and service of process, and International Schuko v. Washington, 326 U.S. 310, 1945, which modernized jurisdictional inquiry around minimum contacts and notions of fair play and substantial justice. To supplement the statutory and case law trail, consult the channel's source file, listed as SRC 90840D7E57, titled Contract Law, Agency Law, and the Law of Presumptions. That research memo compiles academic and doctrinal authorities on agency relationships, powers of attorney, and the presumptions courts employ when a party appears to accept obligations connected to another's legal status. Together, these documents reveal how administrative instruments, grant agreements, and statutory authorities intersect to produce both written records and legal presumptions about who is acting, in what capacity, and under which rules. Public versus private capacity is the axis on which much of this analysis turns. When a person applies for and accepts a federal grant, agencies typically treat that person or entity as a recipient, a legal category defined in the uniform guidance that carries specified duties: record-keeping, reporting, compliance with non-discrimination and audit requirements, and submission to performance oversight. At first glance, these obligations may look like contractual terms. In many respects, they are. A grant agreement is a regulatory financial instrument. It creates expectations and duties between the federal government and the recipient. The acceptance of funds functions as mutual assent to terms laid out in statute, regulation, and the grant instrument itself. In legal language, that can create an agency-like relationship, or at minimum a contractual relationship with regulatory overlay. Agency law becomes relevant where a recipient performs functions or exercises powers that implicate another's authority. For example, when a state or local government administers federal funds to beneficiaries, it often becomes a pass-through entity that must ensure subrecipients comply with federal conditions. That delegation can be framed as an agency or fiduciary role. The pass-through must perform oversight, report, and in some cases enforce federal rules on third parties. Courts and agencies treat those delegated responsibilities seriously because they produce an administrative record and because they create a chain of legal obligations separating public and private capacities. Distinguishing capacity is crucial. Compliance undertaken in an official or representative capacity may expose a political subdivision or a private actor to different liabilities, remedies, and jurisdictional assertions than actions taken purely in a private, personal capacity. Presumptions are the doctrinal shortcuts courts use when the fact finder lacks a complete picture. One significant presumption is constructive acceptance. By receiving funds and not timely rejecting the attached terms, a recipient is presumed to have consented to conditions. That presumption shifts burdens of proof and can create jurisdictional consequences. For administrative jurisdiction, acceptance of grant terms often authorizes agency monitoring and enforcement, which may include administrative hearings or referral to federal courts. Relatedly, the consent to jurisdiction concept can be implicit in contractual terms that specify dispute resolution mechanisms, venue clauses, or forum selection provisions. The uniform guidance and many grant agreements include mandatory clauses, such as audit access, record retention, and certification statements, that effectively operate as consent to administrative processes and indirectly to judicial review paths. Historical jurisdictional doctrine helps map how those presumptions operate. Pennoyer's territorial model emphasized formal service and physical presence, but modern administrative and civil practice resemble the international SHU framework. Jurisdiction is assessed by whether the relevant contacts, here, contractual undertakings, the receipt of ongoing funds, continuous reporting obligations, and the performance of duties under the grant, are sufficient to satisfy notions of minimum contacts or to justify administrative reach. Courts have recognized that entering into a structured funding relationship with the federal government can amount to deliberate affiliation with the forum that supports jurisdictional assertions. That is particularly true where statutory language or grant terms explicitly condition eligibility or ongoing support upon submission to oversight or remedies. But not every acceptance of funds collapses private rights into public authority. The content of the grant instrument matters. Are the terms prescriptive about how activities are carried out? Do they require the grantee to act as an arm of the government, to exercise statutory-like powers, or to enforce federal standards against third parties? Do they require the grantee to carry out tasks in a public capacity, dispersing benefits, licensing, or adjudicating entitlements? Where the relationship demands such public functions, courts are more likely to find agency or quasi-governmental capacity and therefore to treat the recipient differently for jurisdictional and immunity purposes. Conversely, grants that reimburse discrete costs or fund independent private activities, research grants with minimal conditions, for instance, more often preserve private capacity and reduce the force of constructive consent presumptions. Finally, the record. Administrative instruments create records, applications, grant agreements, certifications, reports, audit findings, and enforcement letters. Those records are the primary means by which agencies establish a recipient's duties and compliance history. For jurisdictional disputes, those documents often supply the key facts showing whether a party knowingly agreed to terms, whether compliance was met, and whether the agency followed required procedures under the APA. In short, accepting a grant makes a paper trail. That trail is the highway on which presumptions about consent and jurisdiction travel. If you want to trace these dynamics yourself, here are precise documents and questions to pursue. Read OMB's Federal Register Notice, Regulation for Federal Financial Assistance, FRDoc 2026-1087, May 29, 2026. Compare the proposed revisions with the codified baseline at 2 CFR P200, the Uniform Guidance. Identify specific new or revised definitions, recipient, subrecipient, pass-through entity, and any language on mandatory terms, and note how they alter duties or reporting requirements. Examine the Administrative Procedure Act 5 U.S.C. 551 at SEEK, alongside the preamble and notice and comment history for FRDoc 2026-1817, to understand how procedural steps create administrative records and how agencies justify regulatory reach. Then read statutory grant authorities in Title 31 of the U.S. Code or the enabling statutes for a particular grant program to see where Congress authorized conditions, auditing powers, or enforcement mechanisms. Compare jurisdictional case law. Read Pennoyer v. Neff, 95 U.S. 714, 1878, and International Shoe Co. v. Washington, 3-26 U.S. 310, 1945. Then identify relevant administrative or federal court decisions where courts addressed whether grant acceptance created consent to jurisdiction or agency-like duties. Look for cases involving pass-through entities, conditional funding, or grant-required certifications. Consult the source memo SRC 90840D7E77 for doctrinal citations on agency, powers of attorney, and presumptions. Map those citations to specific clauses in sample grant agreements. Seek publicly available grant contracts from grants.gov or agency grant program pages. Practical document searches. Obtain a sample Notice of Funding Opportunity, NOFO, and its award terms for a federal program of interest. Get a recent single audit report that references federal award compliance findings, and locate administrative enforcement letters or demand letters tied to grant noncompliance. Ask these targeted questions when you read: which terms require affirmative action that looks like public authority? Which clauses create continuing reporting obligations? Where does the grant instrument specify dispute resolution, venue, or consent to administrative access? Where statutes or regulations reserve remedial discretion to the agency, how are those remedies triggered and documented? These documents and questions will help you trace how a seemingly simple financial transaction can summon a constellation of legal presumptions and jurisdictional
tipsy. Them politicians, them gone crazy. Drunk off the wine of greed and vanity. Forget about the people and the family. Tipsy. Them politicians, them gone crazy. See corruption, chase it with dishonesty. Trip over justice, fall upon inequality.